Ever been caught in a construction project where payments seem to get stuck, disappear into a black hole, or worse, just never materialized? It's a common nightmare in the building industry where cash flow isn't just important, it's absolutely vital. Delays in payment can quite literally bring a business, especially a smaller one, to its knees. Today, we're taking a comprehensive deep dive into a powerful, almost revolutionary piece of legislation designed specifically to prevent that nightmare from becoming a reality. The Building and Construction Industry Security of Payment Act 2009 in South Australia. We'll be referring to it often as simply the SA Act, our mission. To unpack its profound purpose, explain exactly how it works, and reveal what it fundamentally means for anyone and everyone involved in construction in South Australia, from the multi-million-dollar head contractors right down to the smallest subcontractor, supplier, or even a solo consultant.
Yeah, and you've entrusted us with a really robust stack of critical documents for this deep dive, everything from the SA Act itself to insightful legal analyses and incredibly practical real-world guides. Our mission here for you is to distill those hundreds of pages into the most important nuggets of knowledge, the truly surprising facts, and those essential insights that cut through the legal jargon. We want you to quickly grasp what this legislation is truly about, understand its significant impact on your bottom line, and see how it's evolved or perhaps resisted evolution over time. We'll meticulously explore its core mechanisms, from the precise steps of making a payment claim through the rapid-fire process of adjudication, and even the often misunderstood avenues for judicial review. And crucially, we'll delve into the regulations governing the independent professionals who resolve these disputes, ensuring fairness throughout.
Okay, so whether you're a busy head contractor trying to manage your obligations, a subcontractor desperate to ensure you get paid for your hard work, or even just someone genuinely curious about how this often complex industry protects its players, this deep dive is your shortcut to being genuinely well-informed. We're here to give you those essential aha moments and truly practical takeaways that will help you navigate this intricate yet absolutely vital area of law with confidence. Okay, let's unpack this foundational piece of legislation then. At its heart, the SA Act is more than just a law. It sounds like it's a crucial financial safety net. But what exactly is it designed to do for anyone working in South Australian construction?
Precisely. You've hit on the core intent. Its formal title, for those interested in specifics, is the Building and Construction Industry Security of Payment Act 2009, SA. But its core object, which is clearly articulated within the Act itself, is to ensure a fundamental principle that anyone who undertakes construction work or supplies related goods and services under a construction contract is not only entitled to receive regular interim progress payments, but perhaps even more critically, is also able to recover those payments. This entitlement is a powerful statutory right that exists even if the contract itself doesn't explicitly mention progress payments or, a payment schedule.
Really? Even if it's not in the contract?
Exactly. The Act overrides that silence. It was specifically enacted to combat pervasive industry issues. Chronic late payments, the severe strain these delays place on cash flow for businesses, and the significant financial risks that subcontractors, in particular, often face due to non-payment.
So why was this specific law needed in South Australia? I mean, what problems was the construction industry facing that prompted the creation of such a targeted act? It sounds like there was a major systemic issue.
You're absolutely right. The construction industry has historically, and rather notoriously, grappled with chronic cash flow issues throughout its supply chain. It's a known problem. Payments can be delayed for months, or even worse, outright denied, due to what are often referred to as manufactured disputes.
Manufactured disputes, what does that mean exactly?
Well, these aren't always genuine disagreements about the work, Sometimes they're strategic, designed purely to delay payment, especially during periods of tight cash flow for the payer, or very notoriously around holiday seasons.
Ah, the holiday ambush.
Exactly. The Act was directly designed to prevent situations where recipients of payment claims might miss critical deadlines or find themselves poorly positioned to respond effectively. This is particularly true with those ambush claims. These are the infamous claims intentionally served just before or during holiday shutdowns when businesses might be operating with a skeleton staff or even completely closed. This makes it incredibly difficult, almost impossible sometimes, for the recipient to meet the strict response deadlines.
Yeah.
And the legislation directly targets these vulnerabilities to try and level the playing field.
Okay, this is where it gets really interesting, I think, and probably the most talked about aspect of this legislation. I've heard this phrase thrown around: pay now, argue later. Ah, can you really be forced to pay disputed money up front? What does that actually mean in practice under the SA Act? It sounds quite radical.
It is quite radical, and it's the procedural backbone of the Act. It's a truly fundamental, almost counterintuitive principle that distinguishes this type of legislation. What it means is that the Act establishes a rapid, enforceable pathway for a claimant to recover money owed without having to endure the lengthy and often prohibitively costly process of traditional litigation in court.
Okay.
The core overriding idea is to maintain liquidity and keep money, that lifeblood flowing within the construction industry. This prevents a business's cash flow from being choked by a payment dispute. However, and this is a crucial nuance that often gets misunderstood, the Act does not finally determine the underlying merits of any disputes about payments or defects or delays or variations or incomplete works.
Ah, okay, so it's not the final word.
Not at all. Think of it like a temporary payment order. Parties are absolutely still free to pursue their deeper underlying contractual claims later in a traditional court setting. So it's about providing a quick and inexpensive resolution for interim cash flow,
Yeah.
ensuring payments continue,
Right.
not a final judgment on the overall contractual relationship or who is ultimately right or wrong in the long run. That can still be fought out later.
That makes a lot of sense. Keeping the money moving is key. So, what kind of construction work or contracts does this incredibly powerful act actually apply to? Is it just for huge multi-million-dollar commercial projects, or does its reach extend much further into the industry?
That's an excellent and often surprising question because it's precisely where the Act's power truly lies. You might initially imagine it's only for those massive commercial bills, but actually, the SA Act has a remarkably broad scope. It applies to any construction contract, regardless of whether that contract is a formal written document, a verbal agreement, or even a combination of both.
Wow, even verbal agreements.
Yes, even handshake deals, although definitely not advisable for other reasons, are still covered by the Act. The absolute key jurisdictional requirement is that the construction work itself must be carried out in South Australia. What's particularly significant and a strong public policy statement is that it applies even if the contract explicitly states it's governed by another jurisdiction's law, say Victorian law. The SA Act overrides that if the work is an SA.
That's powerful.
It makes it very difficult to contract around the Act's protections. And when we talk about construction work, the Act provides an incredibly detailed list, really showcasing its sheer breadth. It covers virtually every type of physical work you can think of that transforms or maintains a site. From the obvious, like the construction, alteration, repair, or demolition of buildings and structures, to vital infrastructure, like roadworks, power lines, telecommunication apparatus, docks, railways, and pipelines. It even includes preparatory work like site clearance, earth moving, excavation, tunneling, boring, laying foundations, and the erection or dismantling of scaffolding. What's often overlooked is that it also extends to things like prefabrication, whether that's done on-site or off-site, site restoration, landscaping, and even painting and decorating. It's designed to be incredibly comprehensive.
So it really covers the whole spectrum.
Absolutely. And furthermore, the definition of related goods and services is equally broad. It covers materials, plant, and a wide array of professional services. Architectural, design, surveying, quantity surveying, building engineering, interior and exterior decoration, landscape advisory, and other technical services. Importantly, it explicitly extends to cover project management, contract management, and consultancy services related to construction work.
Okay, so consultants and project managers too.
Yes. So it truly aims to cover almost every single player in the construction ecosystem, from the diggers to the designers and the project managers. The only major exclusions are things like the drilling for or extraction of oil, natural gas, and mineral extraction. Those specific resource industries are carved out.
That's fascinating how comprehensive it is. But with such broad coverage, are there any contracts or specific clauses that this act specifically doesn't cover, or perhaps that it outright forbids? It sounds incredibly powerful, but there must be some boundaries.
Yes, absolutely. The Act does have very clear boundaries and some critical prohibitions. First, it does not apply to domestic building work contracts if the property owner resides or intends to reside in the premises where the work is being carried out.
Ah, the homeowner protection.
Exactly. This is a common exclusion in security of payment legislation across Australia, designed to protect individual homeowners from potentially complex commercial payment mechanisms. However, it's vital to note that it can apply to larger residential developments or investment properties where the client isn't the intended occupant. So it's not a blanket exclusion for all residential building work.
Right. Okay.
It also explicitly excludes purely financial arrangements like loan agreements, contracts of guarantee, or insurance contracts provided by recognized financial institutions. And significantly, employment contracts are excluded.
So employees can't use it for wages.
Correct. This means that individual employees cannot use the Act to claim wages or salaries. It's about commercial contracts for worker supply, not employment relationships. What's particularly fascinating and a real cornerstone of the Act's protective nature is that it also explicitly prohibits what are commonly known as pay-when-paid clauses.
Right, I've heard of those.
These are contractual provisions that attempt to make one party's liability to pay another party contingent upon the first party receiving payment from someone else, usually higher up the chain. The Act declares such clauses to have no effect. They are completely void, as if they were never written into the contract.
So they're just ignored.
Completely ignored. That this is a critical protection designed to prevent, say, larger contractors from delaying payment to a subcontractor simply because they haven't yet been paid by the principal or developer. It forces the payment obligation down the chain regardless of the top-tier payment status.
So if I'm signing a construction contract in South Australia, I can't just put a clause in there saying, hey, we agree this act doesn't apply to us, or we're contracting out of these provisions. What does this mean for trying to opt out?
You've hit on one of the Act's most robust safeguards. The Act is unequivocally clear on this. It states that it's not possible to contract out of its provisions.
You just can't do it.
You just can't. Any contractual provision, whether written or not, that attempts to exclude, modify, or restrict the operation of the Act, or even a provision that could reasonably be construed as an attempt to deter a person from taking action under the Act,
Right.
is declared void. It's legally ineffective. This is a powerful legal safeguard, a true shield designed to ensure that the protective intent of the legislation cannot be circumvented by clever contractual drafting or private agreements. It truly maintains its effectiveness in ensuring cash flow throughout the construction supply chain, regardless of what private agreements parties might try to make. It's essentially a non-negotiable legal framework for the industry in SA.
Good to know.
And it's also worth noting, just briefly, that the SA Act operates in parallel with a much older piece of legislation, the Workers' Liens Act, 1893, SA. This older act provides additional rights for claimants to have a lien over the land where the work was done, which can offer another layer of security for payment in certain circumstances. It works in conjunction with the more modern security framework.
Interesting. So there's another layer there, potentially.
Potentially, yes, though the Security of Payment Act is usually the more direct and faster route these days.
Okay, so we know the why and the what of the SA Act now. Let's delve into its history a bit. Where did this powerful law actually come from? Was it a completely new invention for South Australia, or did it have siblings or predecessors elsewhere that influenced it?
Yeah, not at all a new invention, which is fascinating because it gives us this rich body of interpretation to draw upon from other places. The SA Act officially came into force on December 10th, 2011.
Okay, so just over a decade ago.
That's right, making it one of the later Security of Payment Acts to be fully implemented across Australia. What's truly insightful here is that it's closely modeled on the Building and Construction Industry Security of Payment Act, 1999, NSW.
Ah, the NSW Act.
Yes, which was actually one of the earliest and critically most influential pieces of such legislation in Australia. In fact, the SA Act shares more similarities in its patterns, procedures, and features with the NSW Act than almost any other Australian state legislation. There are only minor differences in most aspects.
So they're almost twins.
Very close relatives, yes. This direct lineage means that South Australian courts often look to judgments from NSW courts for persuasive guidance when interpreting and applying the SA Act, unless there's a significant textual difference between the two statutes on a particular point. It effectively provides a pre-existing legal roadmap for SA courts, which is quite helpful.
Right. Given its origins in NSW and its clear purpose, has the Act just stayed the same since 2011, or have there been attempts to change and refine it over the years? Because in an industry that evolves so rapidly, you'd almost expect the legislation to need tweaks to keep pace.
That's a crucial observation. And you'd think so, wouldn't you? Despite its strong foundation, there have been several significant proposals and concerted attempts at reform over the years. These reflect ongoing industry feedbacks and broader national discussions on best practices for security of payment. For example, back in May 2015, we saw the release of the Moss Report, prepared by former Youth and District Court Judge Alan Moss. This report, which carefully considered submissions from across the industry, actually recommended some pretty radical changes.
Like what?
Well, it suggested abolishing the existing authorized nominating authorities, or ANAs, the bodies that appoint adjudicators, and transferring all their functions to the Small Business Commissioner. The idea was the commissioner would then be solely responsible for handling all adjudication applications.
Centralizing it.
Exactly. It also proposed introducing longer timeframes for complex claims, recognizing that not all disputes are simple enough for the standard fast-track process, and advocated for a better process for appointing consistently competent adjudicators. And the SA government even considered further regulatory options following the collapse of prominent Adelaide commercial builder Tagara in that same year, which really highlighted the real-world impact of payment issues.
Yeah, those collapses always focus the mind.
They do. Then, in 2017, the Building and Construction Industry Security of Payment Review Amendments Bill was introduced into Parliament. This bill specifically aimed to tackle one of those notorious pain points we discussed earlier, extending the critical Christmas shutdown period for calculating business days under the Act. It proposed stretching it from December 22nd right through to January 10th of the following year.
That would make a difference.
It would. And it also sought to impose regulatory measures to address potential biases within the ANAs themselves, aiming to enhance impartiality in the adjudicator appointment process.
So, a bill specifically addressing those frustrating holiday period issues, the ambush claims, which seems like such a practical, immediate concern for businesses? But you're saying it didn't pass. That seems like a major missed opportunity given how common that problem sounds.
You've hit on a crucial point there. Indeed, that 2017 bill ultimately lapsed. It didn't make it through Parliament to become law.
Why not?
Well, these things often face hurdles. It really highlights the inherent difficulty in implementing such reforms, even when they address known, widespread industry pain points. There's often a significant amount of, let's say, legislative inertia or competing priorities at play. And this wasn't just a South Australian conversation either. There was also a broader national effort, the 2018 Murray Review.
Ah, yes, I remember hearing about that.
This was a major comprehensive national review of security of payment laws across Australia, conducted by Mr. John Murray AM. It was explicitly aimed at identifying best practices and, crucially, harmonizing legislation across different jurisdictions to strengthen protections, particularly for subcontractors, and ensure greater consistency. The Murray Review made a substantial 86 recommendations, which gives you a sense of the scale of the challenge nationally.
86. Wow.
Yes. However, it notably differed from some earlier suggestions, for instance, by opposing a two-tier system for claims where complex claims would follow a different, perhaps longer process. It also opposed the routine publication of adjudicator determinations, which is still a point of ongoing debate regarding transparency versus privacy.
Right.
Most recently, and perhaps most tellingly, in 2021, the Building and Construction Industry Security of Payment Review Recommendations Amendment Bill 2021 was introduced into the SA Parliament. This bill was quite comprehensive, directly incorporating many of the Murray Review's recommendations, indicating a strong desire for legislative alignment with those national findings.
So, trying again, basically.
Trying again and incorporating those national recommendations. It proposed significant changes, such as bringing domestic building work contracts, even those where the owner resides or intends to reside under the scheme, which would have been a massive shift for homeowners and small builders. It also aimed to remove the concept of reference dates, which we'll discuss in more detail soon, but which are currently key to triggering when a claim can be made.
Okay.
Furthermore, it proposed extending the reach of adjudication to disputes specifically about the payment of retention money, those amounts often withheld from progress payments until project completion. And it sought to assign responsibility for adjudicator registration to the Small Business Commissioner, echoing that earlier Moss report suggestion to centralize oversight.
That sounds like a really substantial overhaul.
It really did. But yet again, despite all this effort and the backing of a major national review, this 2021 bill also lapsed when Parliament was dissolved by the governor in February 2022, prior to the state election. It just didn't get across the line in time. So to summarize, despite these extensive efforts and the recurring recognition of potential areas for improvement, as of the last available information in your sources, the SA Act still remains in its original 2009 form.
Still the 2009 version.
Yes. The proposed amendments from 2017 and 2021, incorporating many of the Murray Review's recommendations, simply did not come to fruition. This leaves South Australia with one of the older, yet still highly effective security of payment frameworks in the country.
So, what does this tell you, I guess, about the legislative process and perhaps the construction industry itself? It seems like there's agreement reform is needed, but it just doesn't happen. It shows that while there's a strong existing foundation in place with the original act, the debate around how to make these laws even more effective, consistent, and fair is very much ongoing. It's a living piece of legislation, conceptually, even if it hasn't formally changed much recently.
That's a good way to put it. And the challenges in achieving consensus and the parliamentary passage for reforms often come down to the sheer complexity of balancing those competing interests.
Like what?
Well, ensuring subcontractors get paid quickly, which is the primary aim,
Right? Yeah.
while also avoiding undue administrative burdens or financial risks for head contractors and principals. Finding that sweet spot for such nuanced legislation, even with broad agreement on the need for reform, proves incredibly challenging in the political landscape.
So for now, businesses and individuals in South Australia are still operating under the 2009 framework, which is why understanding it intimately is so crucial. You can't rely on proposed changes. You need to know the law as it stands.
Absolutely. You have to work with the rules that are actually in force.
Okay, let's get into the practical side then. The nuts and bolts of how this act helps people get paid. If you've done the work or supplied the goods, who can actually initiate this process of making a claim under the act? Is it an exclusive club?
No, absolutely not an exclusive club. Anyone who has undertaken to carry out construction work or supply related goods and services under a construction contract can serve a payment claim. This is a very broad right, and it deliberately includes everyone from the head contractor at the top of the supply chain all the way down to subcontractors and even material and plant suppliers.
Suppliers too.
Yes, it's designed to cast a wide net and protect anyone who has contributed tangible work or materials to a construction project, ensuring they have a mechanism to demand payment for their efforts.
You mentioned reference dates earlier as something the reforms try to remove. Under the current act, what exactly are they and why are they so important as the trigger for making a claim?
Okay, reference dates. They are essentially the legal trigger, the precise moment in time when a payment claim can actually be made under the Act. They provide a clear and predictable cycle for seeking payments, ensuring some regularity. There are two primary ways a reference date is determined. First, it's either a specific date determined by or clearly outlined in accordance with the terms of your construction contract for making claims.
So whatever the contract says.
If the contract specifies it clearly, yes. So, for example, if your contract states claims can be made on the 25th of each month for work completed up to that point, then the 25th of each month is your reference date. Simple enough. Second, and this is crucial for contracts that are less specific or even silent on this, if the contract doesn't explicitly specify a date, the Act provides a default mechanism.
A fallback position.
Exactly. In this default scenario, the reference date becomes the last day of the named month in which the construction work was first carried out or the related goods and services were first supplied under the contract, and then it's the last day of each subsequent named month after that.
So end of the month, basically.
End of the month as a default. This ensures that even if a contract is silent on payment cycles, there's always a clear, regular point from which progress payments can be sought. Now, a payment claim can only be served on or from each reference date. You can't claim for work done after the reference date has passed for that claim period or, submit it before the reference date has actually arrived. It anchors the claim to a specific period.
Okay, that makes sense.
And once that reference date has passed, there are strict time limits for actually serving the payment claim. A claim must be served either within the period specified in your construction contract. So, for example, if your contract says claims must be submitted within 7 days of the reference date, that applies. Or if your contract doesn't specify a time frame, or if that contractual period is shorter than the statutory one, you have a statutory period of 6 months.
6 months from when?
6 months after the construction work to which the claim relates was last carried out, or the related goods and services were last supplied, whichever period is later. It's incredibly important to note that this 6-month period for SA is actually shorter than in some other states like NSW, where it's 12 months.
Oh, that's a big difference.
It is. So claimants in South Australia have a more constrained window to get their claim in, which really underscores the need for diligence. Don't sit on your claims.
Right. And how many claims can you make? Can you just keep sending them?
No, the Act is quite specific on this. A claimant can only serve one payment claim for each specific reference date. You can't bombard a respondent with multiple claims for the same period. However, here's an important practical point. An amount that was previously claimed in an earlier period but perhaps wasn't paid or was disputed and not fully resolved can absolutely be re-included in a new payment claim relating to a subsequent reference date.
Ah, okay. So you can carry over unpaid amounts.
Exactly. This is particularly relevant for ongoing projects where disputes might persist or where small amounts might have been overlooked or partially paid in earlier claims. You don't lose the right to claim it just because it was in a previous claim.
Okay. So if I'm preparing a claim for work I've completed, what absolutely must be in it for it to be considered valid under the Act? This sounds like a place where small errors could have major consequences, potentially invalidating the whole process if you get it wrong.
This is absolutely foundational, and you're right. A seemingly small error here can derail the entire process and prevent you from using the Act's powerful protections. It's surprisingly easy to get wrong. A payment claim must meet three specific, non-negotiable requirements to be valid under Section 13 of the Act. First, it must clearly identify the specific construction work or related goods and services to which the progress payment relates. This isn't just about saying work done. It needs to be clear enough for a reasonable person receiving it to understand exactly what they're being asked to pay for. Ambiguity is fatal.
Okay, be specific.
Be specific. Second, it must indicate the exact amount of money the claimant claims to be due. This is referred to as the claimed amount. It needs a clear, precise dollar figure. And third, and critically, it must explicitly state that it is made under the Building and Construction Industry Security of Payment Act, 2009, SA.
The magic words.
Exactly. Those are the legislative magic words that activate the Act's mechanisms. Simply including the claim details as part of a regular invoice might not be enough if it doesn't contain this explicit statement. It has to be flagged clearly as an Act claim.
That's a key takeaway right there.
Absolutely. And the claimed amount itself can be quite flexible in what it covers. It can include retention monies that are due for release or even amounts payable if you've had to legitimately suspend work under the Act's provisions due to non-payment by the respondent.
Okay, so I've got my valid claim. I've included the magic words. How do I make sure the other party actually receives it properly to trigger those strict timeframes? And what's this about ambush claims, especially around holidays? It sounds like a real minefield for businesses, particularly at year-end.
You've hit on a truly crucial point because to meet these strict time frames, effective service of the payment claim is absolutely paramount. If you can't prove they received it properly, your claim might fail before it even starts. The Act specifies several valid methods. Payment claims can be served personally, literally handing it to them, or by lodging it at their ordinary place of business during normal business hours, or by sending it by post or fax to their ordinary place of business.
Fax. Do people still use fax?
Believe it or not, it's still listed in the Act, though less common now, obviously. Electronic service, particularly email, may also be effective.
Maybe.
Yes, maybe. This often depends on whether there's been prior agreement between the parties for electronic service, maybe stated in the contract, or if the ongoing circumstances of communication indicate it's an accepted and regularly monitored method between those parties. You can't just assume email is okay if you've never used it before for formal notices.
Okay, I need to be careful there.
Very careful. Service on their registered office, which as you mentioned is often an accountant's office, can sometimes be effective too. But this carries significant risks, particularly during holiday shutdowns when mail might not be regularly monitored. You might send it, it might legally be served on the registered office, but if no one there actually sees it or forwards it for weeks.
The clock is still ticking against the recipient.
Exactly. The clock starts when it's served, not necessarily when it's read. Now, the ambush claim phenomenon is truly notorious in the construction industry, especially around that end-of-year holiday period. Claimants might strategically serve claims just before or during holiday periods, knowing that cash flow is often tightest for businesses at this time, and that many might be operating on skeleton staff or be completely shut down until well into January.
Using the system tactically.
Precisely. This strategy significantly increases the likelihood that a recipient will miss the tight deadlines for response or be poorly positioned to assess and respond effectively. This can potentially force them to pay disputed amounts simply because they couldn't get their act together in time. It's a tactical move, maybe sharp practice, but a very real threat to businesses.
Right. Does the Act account for Christmas shutdowns at all?
It does, partially. While the SA Act does provide some extra time around specific December dates defining a business day as any day other than Saturdays, Sundays, public holidays, or December 27th to 31st, inclusive.
Okay, so that week between Christmas and New Year is excluded.
That specific block is excluded. However, its full extent regarding broader statewide shutdown definitions is uncertain and has been a source of confusion and debate. The Act uniquely mentions excluding days of statewide shutdown.
What does that even mean?
Well, that's the problem. Some argue this statewide shutdown should realistically include things like union roster days off that affect the whole industry, or maybe the entire 2-week traditional holiday period when most building sites and offices are closed. However, the legal position is not definitively settled, and courts have often interpreted these kinds of exceptions quite narrowly.
So don't rely on it.
Exactly. To avoid unnecessary arguments and significant financial risk, businesses should never rely solely on that vague statewide shutdown exception if they don't plan to reopen until, say, mid-January. It's a very risky assumption that could cost you dearly if a court disagrees with your interpretation of statewide shutdown.
Okay, very clear warning there. So for businesses caught in this holiday period crunch, or really any time when they might be short-staffed or slow to react, what truly practical steps can they take to protect themselves from these ambush claims and just generally manage payment claims under the Act effectively? What's the game plan?
This is where proactive management becomes your best defense. Forewarned is forearmed, as they say. Firstly, businesses should proactively review the status of all their ongoing projects and identify any possible issues that might lead to payment claims and disputes before they arise. Anticipation is absolutely key. Secondly, it's absolutely crucial to identify the progress claim reference dates in all your construction contracts, or understand the default reference dates if the contract is silent, so you can accurately anticipate exactly when payment claims might legitimately be made against you. You want to be ready, not surprised when one lands on your desk.
Know when they're coming.
Exactly. Thirdly, ensure that your entire team, and in particular any contract administrators or project managers who might receive communications, are well trained on how to identify a payment claim made under the Act. Remember, it's not just a regular invoice. It needs that specific statement we discussed earlier to trigger the Act's mechanisms. It needs to be flagged immediately.
Okay, train the team.
Definitely. Operationally, this means that if project managers or other key personnel go on leave, especially over holidays, their emails must be diverted to an address that is checked regularly throughout the holiday period. Don't let claims sit unseen in an inbox. Similarly, ensure your fax machine, if you still somehow use one, and your physical postal mail at your ordinary place of business are monitored consistently. Even a daily check during shutdown periods can save you.
Diligence is key.
Utterly key. You should also check any other addresses for service of notices and claims that might be nominated in your construction contracts. Sometimes there are specific addresses listed, and ensure they are regularly checked, even during shutdowns. It's also very wise to check what registered office address you have nominated with ASIC. This is often an accountant's office, as we said, and proactively contact that office to ensure any payment claims received there will be identified immediately and redirected to the appropriate person within your organization without delay. Don't assume they know what it is or its urgency.
Good practical tip.
Furthermore, make sure your team understands precisely how to respond to a payment claim with a compliant payment schedule that meets all the Act's stringent requirements. Because, as we'll discuss next, the consequences of not doing so are severe and automatic. You need a plan for response, not just receipt. Finally, always confirm the applicable requirements and timeframes under the specific legislation that is in force where the work claimed was carried out. Because timeframes to respond to security of payment claims differ significantly for each state and territory in Australia.
Right, it's not one size fits all nationally.
Not at all. What applies in ASA might not apply in NSW or Queensland, so always check the relevant States Act. Ultimately, seeking professional legal advice immediately upon receiving a claim is always the best course of action, especially if you're unsure about anything. It's far better to be overly cautious than caught off guard by these deadlines.
Absolutely. Okay, so moving on. I've received a payment claim. I've identified it as an SA Act claim, thanks to those magic words. Now, what do I do next, especially if I don't agree with the amount claimed or if I believe I don't owe it at all? This is where the defense comes in, right? This is my chance to push back.
This is indeed the respondent's critical first step, and its importance truly cannot be overstated. If you, as the respondent, do not intend to pay the full amount stated in the payment claim, you must respond with a document called a payment schedule. This is your sole golden opportunity at this crucial initial stage under the Act to formally dispute the claim and clearly outline your reasons for doing so. Failing to provide a valid payment schedule effectively closes off most of your options to dispute the debt under the Act itself.
Okay, so the payment schedule is everything at this point.
It really is. And the time frame for this response is incredibly strict. You must provide that payment schedule to the claimant within 15 business days after receiving the payment claim.
15 business days.
15 business days. Or even earlier if your construction contract specifies a shorter period for responding to claims. Always check the contract first. It's important to note that this 15 business day period in SA is actually longer than the 10 business days allowed in NSW.
A bit more breathing room.
A little bit, yes. But it's still a tight deadline in the context of assessing potentially complex claims. Think of it like a legal shot clock. You absolutely do not want to be the one holding the ball when that buzzer goes off, because missing this time frame has truly severe automatic consequences, which we'll get to in just a moment.
Okay, so what needs to be in that payment schedule?
Right. To be valid under Section 14 of the Act, your payment schedule must identify the specific payment claim it relates to. That's usually straightforward, referencing the claim date or number. And it must clearly indicate the exact amount of the payment, if any, that the respondent proposes to make. This is known as the scheduled amount. It could be the full amount, a partial amount, or zero.
Zero is an option.
Zero is definitely an option if you genuinely believe nothing is payable. Most importantly, if your scheduled amount is less than the claimed amount, or if you propose to pay nothing at all, you must clearly state why it is less and provide specific, detailed reasons for withholding payment.
How specific?
Very specific. Vague responses like, "We dispute this amount due to defective work or cost to complete," are simply not sufficient. The reasons must be detailed enough for the claimant and potentially an adjudicator later on to understand the precise basis of your dispute. What defects? Where? What's the estimated cost of rectification? You need to substantiate your position. This detailed reasoning is crucial because, as we'll see, you're generally restricted to arguing only these specific reasons later on if the dispute progresses to adjudication.
So you can't bring up new arguments later.
Generally, no.
Yeah.
Not in the adjudication under the Act. You lay your cards on the table in the payment schedule.
Wow, okay. So this is the really powerful nugget of knowledge we hear about. What happens if a business, for whatever reason, maybe they were ambushed over Christmas, maybe they just misunderstood the document, maybe the dog ate it just, doesn't respond with a payment schedule at all within that strict 15-day time frame? Does the claim just go away?
Or, and this is exactly where the pay now, argue later principle becomes starkly evident and incredibly powerful. If a respondent fails to provide a payment schedule within that strict time frame, those 15 business days, or the shorter contractual period, they become automatically liable to pay the full claimed amount.
Automatically, just like that.
Just like that.
Yeah.
It's not a suggestion. It's an automatic legal consequence under Section 15 of the Act. They effectively lose their right to dispute that amount at that stage under the Act, and the claimant can then move swiftly to recover it as a statutory debt.
Regardless of whether the claim was actually valid or inflated.
At that point, yes. The Act's mechanism focuses on the procedural failure to respond. The merits can potentially still be argued later in separate court proceedings, but the immediate liability under the Act is triggered by the failure to provide the payment schedule.
That is incredibly powerful.
It is. This mechanism is incredibly powerful because it forces a response and ensures that a claimant's cash flow isn't held up by silence or inaction. It's a very sharp incentive to comply with the Act's deadlines. Ignore it at your peril.
Okay. Message received loud and clear on that one. So, assuming a claim is made or a payment schedule is provided, when does the payment actually become due?
Good question. The payment has a due date. This due date is either the date specified explicitly in the construction contract itself.
Contract first, again.
Contract first. Always check the contract. Or, if the contract makes no express provision with respect to the matter, it defaults under the Act to 15 business days after the payment claim was served. Interestingly, unlike some other states in Australia, which might have different default periods for head contractors versus subcontractors, the SA Act applies this 15 business day default period uniformly to both head contractors and subcontractors where no due date is set in the contract. That ensures some consistency.
And what about interest on late payments?
Yes, if a payment becomes due either by the contract date or the default date and it is not paid, interest is automatically payable on the unpaid amount. No need to specifically claim it initially. It accrues automatically. The interest rate applied is a higher of two options. either the rate prescribed under the Supreme Court Act 1935 SA for judgment debts at that time, or the rate specified in the construction contract itself, if there is one. Whichever is higher applies.
So there's a penalty for paying late.
Absolutely. It provides a clear financial disincentive for delaying payment beyond the due date.
Okay, so let's say a payment claim was made. A payment schedule was submitted on time, but the parties still can't agree on the amount. The claimant wants $100, the respondent says only $20 is due, or maybe the scheduled amount of $20 simply isn't paid by the due date. How does the Act help resolve that specific dispute without immediately spiraling into expensive and lengthy court proceedings? Where do they go next?
That's precisely where adjudication comes in. It's the Act's fast-track statutory dispute resolution process, designed specifically as an alternative to traditional litigation for these kinds of payment disputes. It involves an independent third-party adjudicator who quickly reviews the payment claim, the payment schedule, and any submissions from the parties, and then makes a binding determination on the amount payable.
Binding.
Binding for the purposes of the Act, yes. We'll get to challenges later. The entire process is designed to be swift and efficient, avoiding the protracted nature and cost of traditional court cases, with the primary aim of keeping cash flowing and projects moving forward.
Okay, so how does a claimant kick off this adjudication process? When can they apply?
A claimant can apply for adjudication in several distinct scenarios, and each scenario has its own specific time frame for making the application. It's crucial to get the timing right. First scenario, if the respondent provides a payment schedule on time, but the scheduled amount is less than the claimed amount, your 20K versus 100 K example. In this case, the claimant can apply for adjudication within 15 business days after receiving that payment schedule.
Okay, 15 days from getting the schedule.
Correct. Second scenario, if the respondent provides a payment schedule, saying we'll pay $20, but then fails to actually pay that scheduled amount by the due date. Here, the claimant has 20 business days after the due date for payment to apply for adjudication.
A bit longer there, 20 days after payment was due.
Yes. The third scenario is particularly important for those respondents who fail to respond at all. If the respondent fails to provide any payment schedule and also fails to pay the whole or part of the claimed amount by the due date.
The situation where they become automatically liable.
Exactly. But even though they're liable, the claimant still needs to follow a process to get an adjudication determination if they want one, though they could also go straight to court for the debt. If they want adjudication, the claimant must first notify the respondent in writing of their intention to apply for adjudication.
A warning shot.
A warning shot, exactly. This notice must be given within 20 business days immediately following the due date for payment. This notification actually gives the respondent a second chance to provide a payment schedule. They get 5 business days after receiving this notice to quickly provide one.
A last chance saloon.
Pretty much.
Yeah.
If, even after this second chance, no payment schedule is provided, then the claimant can make the adjudication application. But they must do so within 15 business days after the end of that 5-day second chance period.
Okay, quite specific steps if no schedule is initially provided.
Very specific. These staggered timeframes ensure a fair, structured process, but maintain that crucial pressure on the respondent to engage and state their position, even if late.
Right. And what does the adjudication application itself involve? What do you need to submit?
The adjudication application itself has specific requirements under Section 17 to ensure it's properly constituted and the process can start smoothly. It must be in writing, and it must be made to an authorized nominating authority, or ANA.
What's an ANA?
We'll cover them in more detail later, but basically they are independent organizations authorized by the government to receive applications and appoint qualified adjudicators from their panel. The claimant actually gets to choose which ANA they use from the approved list.
Okay. Claimant chooses the referee organization.
In effect, yes. The application needs to clearly identify the payment claim and any payment schedule it relates to. It can also include any submissions the claimant wishes to make in support of their claim, arguments, evidence, documents, and it must be accompanied by the ANA's application fee. Critically, a copy of the entire adjudication application, including all submissions, must be served on the respondent. This isn't just a courtesy. It's a fundamental requirement of the Act to ensure they are fully aware of the case being put against them and have an opportunity to respond fairly. No trial by ambush here.
That makes sense. Due process is still important, even in a fast-track system. But can the respondent still make their case effectively during the adjudication? Or is their opportunity mostly gone if they didn't get that initial payment schedule precisely right, or if they miss the deadline?
They can still participate, but with a critical and often unforgiving limitation, and this ties back directly to the absolute importance of that initial payment schedule we discussed. A respondent can only lodge an adjudication response if they had already provided a payment schedule to the claimant within the original strict timeframes allowed by the Act. That is, either within the initial 15 business days or within the 5 business days of the second chance notice if one was given.
So if you miss the payment schedule deadline completely, you can't even submit a response to the adjudication.
Correct. If no valid payment schedule was served in time, the respondent generally has no right to lodge an adjudication response under Section 18. They can't participate further than the adjudication itself.
Wow, that's harsh.
It underlines the importance of that first step.
Eh.
And here's the really crucial part for those who did submit a payment schedule on time. The respondent cannot introduce new reasons for withholding payment in their adjudication response if those reasons were not already included in their original payment schedule.
Locked into your original arguments.
Exactly. You are essentially locked in to the arguments and reasons you put forward initially. This strongly incentivizes putting your best case forward with full details in that first payment schedule, because your ability to defend your position later in adjudication is largely predetermined by that first document. Don't hold anything back hoping to use it later.
Okay. And what's the time frame for submitting that adjudication response?
The time frame for the response is also tight, reflecting the fast-track nature. It must be lodged either within 5 business days after the respondent receives a copy of the adjudication application from the claimant, or within 2 business days after they receive notice from the ANA that the adjudicator has accepted the appointment to decide the case, whichever time expires later. So, again, very quick turnaround needed.
Definitely fast track. So once the adjudicator is appointed and they have the application and maybe a response, what do they actually consider and how quickly do they decide?
Once an adjudicator is appointed by the ANA and receives all the documentation, they are tasked with making their determination as quickly as possible. The Act uses the term as expeditiously as possible. Generally, this means within 10 business days after the adjudication response is lodged, or after the date it was due if no response was lodged or permitted.
10 business days. That is fast.
It is incredibly fast compared to court proceedings, though it's worth noting that this time frame can be extended if both parties agree in writing to allow the adjudicator more time, which sometimes happens in more complex cases. Now, the adjudicator's power to determine the matter is quite focused and deliberately limited by Section 20 of the Act. They are constrained in what they can consider. They can only take into account, firstly, the provisions of the SA Security of Payment Act itself. Secondly, the specific terms of the construction contract between the parties. Thirdly, the payment claim and all its supporting submissions and documentation provided by the claimant. Fourthly, the payment schedule, if one was provided, and its supporting submissions from the respondent. And finally, the results of any inspection carried out by the adjudicator if they choose to inspect the site or the work itself.
So they can't just go off on a tangent.
No, they are strictly limited to those matters. They can't consider arguments or evidence unrelated to those specific documents in the Act. They must then provide a written determination, which usually includes reasons for their decision, unless the parties agree reasons aren't needed, which is rare. This determination details the adjudicated amount. The amount, if any, the adjudicator has decided is payable, the date by which that amount becomes payable, and any applicable interest rate. Their job is to assess the payment entitlement based only on the information properly put before them within the Act's framework, not to conduct a full-blown investigation or delve into broader contractual disputes that weren't raised in the claim or schedule.
Okay, so once the adjudicator makes that decision and determines an amount is payable, what happens next? Does the money just appear, or are there further steps needed for actual enforcement if the respondent still doesn't pay? What's the process for getting that money in hand?
Yeah, unfortunately, the money doesn't just magically appear on the claimant's doorstep, but the Act provides incredibly powerful enforcement mechanisms designed to ensure prompt payment following a determination. If the adjudicator determines that an amount is payable, the respondent must pay that adjudicated amount. The payment is legally due either by the specific date set in the determination by the adjudicator, or, if no date is set, within 5 business days of the respondent receiving a copy of the determination from the adjudicator.
Another tight deadline, 5 business days.
Very tight. Now, if the respondent fails to pay the whole or part of this adjudicated amount by that due date, the claimant can then quickly request an adjudication certificate from the authorized nominating authority, ANA, they initially applied to. The certificate essentially confirms the adjudicated debt, and the certificate is incredibly powerful. Under Section 25, it can be filed by the claimant as a judgment for a debt in a court of competent jurisdiction like the Magistrate's Court or the Supreme Court, depending on the amount.
Filed straight into court.
Yes, filed straight into court. And once filed, it is then enforceable, just like any other court judgment or order. This provides a very direct and expedited route to recovery, bypassing the need for a separate, lengthy court case just to prove the debt exists. The adjudication certificate is the proof of debt for enforcement purposes.
That sounds very effective.
It's designed to be. Furthermore, the claimant also gains a significant tactical right if the adjudicated amount isn't paid. They can suspend construction work or the supply of related goods and services under Section 27.
They can just walk off the job.
After giving proper notice, yes, they must first give the respondent at least 2 business days written notice of their intention to suspend work. This powerful right to suspend exists until the adjudicated payment, including any interest, is received. This puts significant commercial pressure on the non-paying party, as it can halt progress on the entire project.
I can imagine. What about costs incurred during suspension?
Good point. If the claimant incurs any losses or expenses as a direct result of this work suspension, for instance, if the respondent consequently removes part of the work from the contract due to the suspension, or if the claimant has costs for remobilization or idle equipment, the respondent is liable for those costs. And importantly, the claimant is generally not liable for any losses or damages suffered by the respondent as a consequence of that legitimate suspension under the Act. This underscores the strong protection the Act provides to claimants who are simply exercising their statutory right because they haven't been paid what an adjudicator determined they were owed. It creates a powerful incentive for respondents to comply with determinations promptly. Okay, that suspension right sounds like a major lever for claimants. Now, this whole pay now, argue later principle and the quick enforcement, it sounds very final at the adjudication stage. But does it really mean you can never, ever challenge an adjudicator's decision in a regular court? Is there absolutely no judicial oversight at all if you genuinely feel the adjudicator got it fundamentally wrong, maybe misinterpreted the contract entirely? It's a nuanced but absolutely critical point, and it's important to understand the distinction the courts make. If a claimant files an adjudication certificate as a judgment debt in court, simply to recover the money owed under the determination, the respondent is generally not entitled in those specific debt recovery proceedings.
Right, in those proceedings.
Exactly. In those enforcement proceedings, the respondent cannot bring a cross-claim against the claimant related to the project, or raise a defense based on matters arising under the construction contract, like defects or delays not properly raised in the payment schedule, or, crucially, challenge the adjudicator's determination on its merits, meaning argue the adjudicator made a mistake of fact or law. The focus in those particular enforcement proceedings is solely on enforcing the adjudicated amount as a debt. The idea, as we discussed, is to get the money flowing quickly, preventing cash flow blockages. So you can't re-argue the contract or the adjudicator's reasoning in those specific debt recovery actions.
Okay, so you can't fight the merits there, but,
and this is a significant caveat, this does not mean there is no judicial oversight whatsoever. The Supreme Court still retains its inherent power to review an adjudicator's decision for what is known as jurisdictional error.
Jurisdictional error. Okay, what does that actually mean?
This is a critical legal distinction. It's different from a simple error of law or fact made within the adjudicator's proper scope of authority or jurisdiction. A jurisdictional error means the adjudicator acted outside their legal authority or jurisdiction. For instance, by exceeding the powers granted to them by the Security of Payment Act, or perhaps by failing to observe a fundamental requirement of the adjudication process that is seen as a precondition to their jurisdiction to even make a decision.
Can you give me an analogy?
Think of it like a referee in a football game. If the referee makes a bad call on whether a player was offside within the existing rules of the game, that's generally seen as an error of fact or law within their jurisdiction. The higher courts won't usually intervene just because they disagree with the call.
Right. Bad call, but still refereeing the game.
Exactly. But if the referee suddenly starts awarding points for things that aren't part of the game at all, or tries to enforce rules from a completely different sport, or kicks a team off for no valid reason under the rules, they're acting outside their authority. That's acting beyond their jurisdiction. That's jurisdictional error.
Okay, I think I get it. It's about whether they had the power to make the decision, not whether the decision itself was correct on the facts or law.
Precisely. It's about whether the adjudicator had the legal authority under the Act to make the decision they made in the way they made it, not whether they made the right decision on the substantive issues as the parties might see it.
That referee analogy really clarifies it. So, what are some concrete examples of these jurisdictional errors that a court might actually intervene on? What kind of fundamental flaws would trigger such a serious legal challenge to an adjudication determination?
Excellent question. Because understanding these examples is key to knowing when judicial review might actually be a viable option, rather than just disagreeing with the outcome. Common grounds for a successful judicial review based on jurisdictional error includes several key scenarios. One major ground is if the payment claim itself did not comply with the Act's fundamental requirements in a way that goes to the adjudicator's jurisdiction to even hear the matter.
So, flaws in the initial claim document.
Yes, fundamental flaws. For example, if it failed to properly identify the construction work claimed for, making it impossible for the respondent or adjudicator to understand it, or if it was premature because it was served before a valid reference date was actually available under the contract or the Act, that reference date being a fundamental precondition to making a claim. Or another example might be if supporting documents crucial to understanding or quantifying the claim were supposedly provided via an internet link, but that link was broken or not accessible to the recipient on the reference date, effectively denying them the opportunity to properly assess the claim when it was made. If the payment claim is fundamentally flawed from the outset in these ways, the adjudicator may lack the initial jurisdiction to validly determine it.
Okay, that makes sense. What else?
Another significant ground is a denial of natural justice or procedural fairness. This broadly covers situations where the adjudicator didn't act fairly or impartially during the process itself.
Like being biased.
Bias is one aspect, but it's broader. Examples include if the adjudicator failed to invite further submissions or evidence from the parties on a critical issue they identified before making a decision based on it, or if they based their decision on a line of reasoning or a point of law that was not raised by either party without giving the parties a chance to comment on it first.
So, deciding based on secret information or arguments.
Essentially, yes.
Mm-hmm.
Or it could be evidence that the adjudicator simply did not read or properly consider the submissions put before them at all, perhaps missing key arguments or evidence, or failed to properly consider the adjudication response provided by the respondent, or perhaps failed to even mention a critical issue raised by one of the parties in their written determination, suggesting they ignored it. All these can indicate a fundamental denial of procedural fairness, which is considered a jurisdictional error because a fair hearing is fundamental to the adjudicator's authority. A reasonable apprehension of bias on the part of the adjudicator, or even sometimes the authorized nominating authority, A&A, that appointed them, can also lead to a successful judicial review.
How would that arise?
Well, for instance, there was a case mentioned where the claimant was assisted by an expert who also happened to be the general manager of the A&A that appointed the adjudicator. That relationship could certainly raise concerns about impartiality and fairness in the appointment process itself, potentially tainting the whole determination.
Yeah, that sounds problematic.
And finally, as we touched on before, if a valid reference date, which is that foundational precondition for a valid payment claim to be made under the Act, was not actually available under the contract or the Act when the payment claim was served, that too can constitute a jurisdictional error. The adjudicator simply has no power to determine a claim that had no valid basis for being made at that time. These are the kinds of fundamental procedural errors or errors going to the adjudicator's very authority that courts will still scrutinize, ensuring the integrity of the process, even if they won't relitigate the facts or simple legal disagreements.
Okay. And what about stopping the money from being paid out if you are challenging the decision on jurisdictional grounds? Can you get an injunction?
Yes, courts also have the power to grant an interlocutory injunction or a stay of execution of the judgment debt that arises from filing the adjudication certificate. But this is typically only granted if there's a very high risk demonstrated to the court that the claimant would be unable to repay the money if a later court case or the judicial review itself determined they were ultimately not owed it.
So, if the claimant is likely to go broke.
Essentially, yes. If there's a serious risk of insolvency for the claimant, this is a relatively rare situation, as courts generally strive to uphold the pay now, argue later principle embedded in the Act. They don't grant stays lightly. In these rare instances where a stay is considered, the court would carefully balance various factors: the strength of the arguments for jurisdictional error, the likelihood of the claimant's potential insolvency, the potential prejudice to the respondent if the money is paid out and then becomes irrecoverable, and how the Security Payment Act itself impacts the risk assessment. It provides a limited safety valve for exceptional circumstances where enforcing the immediate pay now could cause irreversible financial harm due to the claimant's inability to repay later.
Makes sense. And how does SA compare to other states on this judicial review issue?
Well, as we said, SA courts largely follow the NSW precedents because the legislation is so similar, meaning jurisdictional error is the main avenue for review. It's worth noting briefly that differences exist elsewhere. For example, the ACT's Security of Payment Act originally contained a clause that explicitly tried to prohibit judicial review based on errors of fact or law. This initially led to some debate, though the courts there ultimately found that they still retain their power to grant prerogative relief, like certiorari to quash the decision, for jurisdictional error, despite the clause. You can't easily remove the court's inherent oversight power. The ACT also uniquely provides an express statutory right to appeal an adjudication determination to the Supreme Court, but only on a question of law, and only with the consent of the parties or leave of the court under specific conditions. That's quite different from SA. The situation in SA, however, aligns much more closely with the approach in NSW and the broader common law principle across most of Australia. Jurisdictional errors remain reviewable by the Supreme Court, ensuring a baseline of legal validity and procedural fairness for adjudications, even if merits review is excluded.
Okay, so judicial review is possible, but only for those fundamental errors of jurisdiction or process. Good to clarify. Now let's talk about the people making these decisions. We've mentioned adjudicators and ANAs. Who are these adjudicators? What makes someone qualified to step in and make these crucial fast-track decisions that can involve millions of dollars? It's a big responsibility.
It absolutely is a big responsibility, and the Act and its regulations set out clear criteria to ensure a certain minimum standard of competency and reliability. Adjudicators must be natural persons, individual people, not companies, and they must possess specific qualifications, expertise, and experience as prescribed by the regulations. In South Australia, Regulation 5 lays this out quite clearly and rigorously. To be eligible to be an adjudicator, a person must have successfully completed a formal training course of at least 2 days' duration, specifically focused on the adjudication of payment disputes in the building and construction industry.
A specific training course.
Yes, and critically, this course must have required the person to pass a written examination, demonstrating their practical understanding of the Act and the process. You can't just attend, you have to pass. Beyond that core training, they must also meet one of the following additional criteria: either hold a degree, diploma, or other relevant qualification in a field like law, engineering, architecture, quantity surveying, or building, as prescribed by the regulations, or be eligible for full membership in one or more of the prescribed professional bodies, like Engineers Australia, the Institute of Arbitrators and Mediators, RICS, etc., indicating a recognized professional standing, or hold registration as a building work supervisor under the SA Building Work Contractors Act 1995 that authorizes them to supervise construction work.
So formal qualifications or industry registration.
Exactly. These criteria aim to ensure they have both the necessary legal procedural knowledge from the training and relevant industry understanding or professional background. Crucially, to ensure impartiality and prevent conflicts of interest, there are also clear disqualifications set out in the Act itself, Section 19. An adjudicator cannot be a party to the construction contract they are being asked to determine. That's obvious. Nor can they have been nominated directly by either or both parties in relation to that specific contract. The nomination is meant to come independently from an authorized nominating authority, ANA, not from the parties themselves trying to pick their judge. They also cannot have a material personal interest in the outcome of the adjudication itself, which further safeguards against conflicts of interest and ensures their independence from the parties and the financial result.
Makes sense. And you mentioned these authorized nominating authorities, or ANAs. What exactly is their role in appointing the adjudicators?
The ANAs are the gatekeepers, essentially. The process of appointing these qualified adjudicators is managed by these authorized nominating authorities. These are specific organizations, often industry bodies or private dispute resolution providers, that have been formally authorized by the relevant minister under Section 29 of the Act. Their job is to nominate suitable persons from their accredited panel of adjudicators to determine specific adjudication applications when requested by a claimant. They play a critical intermediary role in the system. They receive the adjudication applications from claimants, they select and appoint an appropriate adjudicator from their pool based on availability and suitability for the dispute, and they manage the administrative side of the adjudication application and later the adjudication certification processes if payment isn't made. They are, in essence, the central administrative hub for the adjudication system.
So, how are these ANAs themselves regulated to ensure they're fair, competent, and not just favoring certain parties or maybe appointing their preferred adjudicators all the time? What kind of oversight exists for these important bodies?
That's an excellent point, because their role is so pivotal to the integrity of the system. The SA government has a specific code of conduct for ANAs that sets out clear obligations to ensure their integrity, fairness, and transparency. It's quite detailed. For instance, ANAs must establish and maintain robust quality assurance systems for their processes. They must also have effective complaint handling systems, so there's a clear mechanism for parties to raise any issues or concerns about the ANA's conduct or the adjudicators they appoint.
Accountability measures?
Exactly. They're required to advise applicants of all application and adjudication fees upfront before accepting an application, which promotes transparency and avoids hidden costs down the track. They must also refund any application fee if a claimant legitimately withdraws their application before an adjudicator does significant work, which provides some flexibility. The code also requires them to allow governmental members, like someone from the Small Business Commissioner's office, to attend any training they provide to adjudicators for the purposes of monitoring the quality of that training, ensuring the standard remains high across all ANAs.
Okay, quality control on training too.
Yes. Perhaps most significantly for ensuring good appointments, the code mandates that ANAs must ensure that any adjudicators they nominate have suitable qualifications and experience for each particular application they are appointed to. It's not just about being on the panel, it's about being right for that specific dispute, considering its complexity and subject matter.
Matching the adjudicator to the case.
Precisely. And they also must ensure there are no real or perceived conflicts of interest when nominating an adjudicator for a specific case. They have a duty to check that. And here are two really important integrity provisions in the code. An ANA must not nominate an adjudicator who has been found by an Australian court to have made technical errors in previous adjudications unless the ANA is satisfied that the underlying cause of that error has been identified and properly resolved, perhaps through retraining.
So, preventing repeat mistakes.
Yes. And furthermore, they cannot appoint a person as an adjudicator if that person has been found by a court or other authority to have acted not in good faith twice or more within the last 5 years in relation to their adjudication duties.
Okay, weeding out the bad apples.
Essentially, yes. These provisions are robust and are designed to uphold the integrity and competence of the entire adjudication process, protecting the system against adjudicators who have demonstrably failed to meet the required standards of competence or good faith.
That's reassuring. What about the cost? Who pays the adjudicator's fees?
Regarding fees, the default position under Section 35 is that both the claimant and the respondent are jointly and severally liable to pay the adjudicator's fees and expenses for determining the application.
Jointly and severally. Meaning?
Meaning the adjudicator can technically recover the full amount from either party if the other doesn't pay their share. However, the Act also states that, between themselves, the parties are typically liable to contribute to those fees in equal proportions, 50-50. Although the adjudicator does have the power to determine different proportions in their decision, perhaps if one party caused unnecessary costs or made frivolous arguments, but equal shares is the starting point. However, there's an important incentive for adjudicators to be timely, as we touched on. An adjudicator may lose their entitlement to be paid their fees if they fail to make a decision on the application within the specified time frame allowed by the Act, that initial 10 business days plus any agreed extensions. This doesn't apply if the application is legitimately withdrawn or the dispute is otherwise resolved beforehand, but it strongly encourages prompt determinations in line with the Act's fast-track intent.
So they don't get paid if they're late.
They risk not getting paid, yes. Furthermore, both adjudicators and the authorized nominating authorities are protected from personal liability under Section 37 for anything done or omitted to be done in good faith while carrying out their functions under the Act. This necessary protection allows them to perform their crucial and often challenging duties without fear of frivolous lawsuits, provided they act honestly and properly.
Okay. So with all these rules, regulations, and protections in place for everyone involved, how effective has the SA Act actually been in practice? Are people actively using this adjudication process, or does its very existence perhaps act more as a deterrent, encouraging settlement? What do the numbers say?
That's a crucial question for understanding its real-world impact and whether it's achieving its objectives. Statistics published periodically by the Small Business Commissioner in South Australia offer some insight into the Act's usage. For instance, looking at a specific period between July 1st, 2021 and March 31st, 2022, that's a 9-month snapshot. There were 24 adjudication applications lodged in the state.
24 in 9 months doesn't sound like a huge number.
It doesn't sound enormous when you consider the total volume of construction activity happening daily across the state. The total claimed value across those 24 applications was significant, though, over $12.6 million. And the total adjudicated amount, meaning what the adjudicators actually determined was payable after reviewing the claims and responses, came to just over $3 million.
So a significant difference between claimed and awarded amounts.
Often, yes. It shows the process is scrutinizing the claims. During this specific period, one particular ANA, Adjudicate Today, was noted as being the most active nominating authority. While these statistics certainly indicate that the Act provides a powerful and utilized tool when needed, they also seem to reflect a relatively low usage rate of formal adjudication in South Australia compared to, say, some other eastern states or the sheer number of contracts out there.
Why might that be?
Well, it could suggest several things. Perhaps the Act's very existence, the threat of adjudication, acts as a strong deterrent, encouraging parties to negotiate and settle payment disputes commercially before they escalate to formal adjudication. That would actually be a sign of success.
The shadow of the Act.
Exactly, the shadow of the Act promoting better payment behavior. Or perhaps many disputes are indeed resolved through direct negotiation or other forms of mediation without needing to invoke the full statutory process. Regardless of the volume, the key point is that the Act shows that while the formal process isn't invoked every single day, it provides a crucial and demonstrably effective pathway for recovering payments when those commercial relationships and negotiations break down. It's a safety net that works when called upon.
Okay, so let's try and wrap this up. What have we really learned from this comprehensive deep dive into South Australia's Building and Construction Industry Security of Payment Act? What are the key takeaways for listeners? It seems clear it's a robust, maybe even aggressive pay now, argue later mechanism. Its fundamental design is to keep cash flowing through the veins of the construction industry, often regardless of what the underlying contract might say about payment terms. It imposes strict, non-negotiable timeframes on making payment claims and, even more critically, on responding with payment schedules. And it provides that fast, efficient adjudication process as an alternative to the courts. All of this seems underpinned by clear rules for the adjudicators and the authorized nominating authorities, aiming for a baseline of fairness and competence. And while it's undeniably powerful in forcing payment, we've learned there are still avenues for judicial review, but specifically limited to those fundamental jurisdictional errors, ensuring that the basic rules of legal process are upheld even in this expedited system.
That's a great summary. And understanding these precise mechanisms, particularly adhering strictly to these timeframes, is absolutely vital for any business or individual operating in the dynamic South Australian construction sector. It's not optional knowledge, it's essential. Being proactive in managing payment claims you make, and especially the payment schedules you provide in response to claims against you, and critically, understanding the severe consequences of inaction or non-compliance, like that automatic liability, can genuinely prevent significant financial pitfalls. It ensures you're either paid promptly and fairly for your hard work, or that you are properly positioned to robustly dispute claims made against you within the Act's framework. Ultimately, as you said right at the start, it's about protecting your cash flow, your business, and your livelihood in an industry where payment certainty is absolutely paramount. Ignoring this Act is simply not an option.
Definitely. Now, this entire discussion, particularly the focus on speed, process, and the difficulties in legislative reform, raises an important question for the future, doesn't it? In an industry driven by tight deadlines and even tighter margins, and given those consistent attempts at legislative reform that haven't quite landed in RSA, how might future technologies, I'm thinking cutting-edge stuff like smart contracts running on blockchain, how might they fundamentally reshape how security of payment is managed down the track? Could they potentially automate compliance? Maybe even automate parts of the dispute resolution process? Could they truly embed the pay now, argue later principle in a frictionless, highly efficient, and transparent way that we can only really imagine today? Reducing human error, delay, and maybe even the need for some of these complex legal mechanisms across the board. It's certainly a provocative thought for what might be next in ensuring people get paid on time.
That's a fascinating thought to end on. The potential for technology to streamline and enforce these principles is huge, but likely brings its own set of challenges too. Definitely something to watch.
Indeed. Thank you for joining us on this deep dive into the SA Security of Payment Act. Stay informed, stay ahead.